If we're to go back in history, the most profound decision around fatigue in legal terms was made in the Australian High Court back in 1990, sometimes referred to as the Jimenez decision. But in this particular court case, which was the classic truck driver fell asleep while driving scenario, and the car going in the other direction, the driver was killed. But what happened in this particular court case was that the driver's legal team argued what has been referred to as the automaton defence. That is, because the driver had fallen asleep at the time of the accident, he was no longer responsible for his actions, in the same way that somebody would not be responsible for their actions if they were under the influence of drugs or alcohol. This has been referred to as the diminished capacity defence. And in that decision, while the judge ruled that it was a reasonable, if somewhat clever, argument by the legal team for the driver, they actually pointed out that they thought that this was not probably the most appropriate way to think about fatigue from a legal perspective. Since that decision in 1990, we have seen a number of critical decisions in Australia that have significantly altered the way that courts think about fatigue in terms of who and why people are responsible for fatigue-related accidents. The first case in which we saw a significant shift away from what has been referred to as the automaton or diminished capacity argument was in the South Australian Supreme Court in the mid-1990s. In that particular case, a police constable had been working on night shift, but as is the case, and is to some extent still the case, he was required to be in court during the day between the night shifts. In that particular court case, he had been scheduled to go to court at around 10 o'clock in the morning. That had been delayed. He had had to then subsequently go home, get ready for work, and then go to work later that night. And having gone to work, he had said to his desk sergeant, "I've been up in court all day and I'm completely shagged, so rather than drive the car tonight, can I drive shotgun?" And to cut a long story short, the desk sergeant at the time had said words to the effect of, "Toughen up, princess. In our days, we used to drive 300 hours without a break," and assigned him to drive the solo car to teach him a lesson. Needless to say, he fell asleep while driving, drove into a Stobie pole, which is one of our fantastic concrete and railroad sleeper telegraph poles that we have in South Australia, and sustained very significant injuries, including brain damage, which he still suffers from. In that particular court case, the judge found that there had been a shift from diminished capacity, and most importantly in that court case, they found that not only was the individual person driving responsible, but so was the employer. And that was a very significant decision because that paved the way for fatigue-related accidents being a workplace responsibility. We've seen a number of criminal and civil prosecutions in the period from 1995 to 2005, and we typically see somewhere in the order of 10 to 12 prosecutions per year in Australia. And most significantly, in around about 2009, we saw the introduction of the chain of responsibility legislation. That was a fundamental change in the legal landscape around fatigue in Australia. And what we saw happen with that legislation was a decision to say that not only is the truck driver responsible in the event of a truck-related accident or a transport-related accident, but so is the employer, and so is everybody in the supply chain for the organisation. And this represents a very significant shift. So not only was the person driving the truck responsible, but so was their employer, and to the extent that other organisations contributed to that, they could also be held accountable. So, for example, there was a very famous case in which a truck driver working for a large hamburger chain had been, in a sense, bullied by the supplier to get goods to particular locations, and as a result was required to break the law in order to do that, under the coercive threat that they would invoke the penalty clauses of some of their contracts. In that particular case, the court found that not only was the driver and the employer responsible, but so was the company for whom the subcontract existed with. That chain of responsibility legislation now covers everybody in the supply chain to the extent that they contribute to the accident. So for example, if we look at remote area livestock transport operators who are carrying cattle from remote Australia into abattoirs in the capital cities, not only is the driver and the employer of that driver responsible, but so are the farmers who own the properties where the cattle are bred, and when they put in a request for somebody to drive cattle from their place to the market, they need to take into account the fact that they are potentially liable for that. What this means over the last couple of years under both criminal and occupational health and safety legislation is that it's no longer possible to outsource your liability. You may remember back to earlier in the course where we talked about the fact that the industrial relations landscape had changed enormously in Australia. One of the things that started to happen in the late 80s, 90s and into the early parts of the 21st century was that organisations took a strategy of outsourcing activities for the organisation to another organisation. So we saw, for example, in the transport industry, trucking companies outsourced to truck drivers who would come to work for them, not as an employee, but as a contractor. In many cases, we have seen organisations outsource risk because those individuals didn't have to necessarily conform to the same fatigue management guidelines that may exist within those organisations. What the new chain of responsibility legislation does is make sure that everybody understands that you cannot outsource. If somebody undertakes an activity on your behalf, whether they are an employee or a contractor, you are responsible in the event that that person has a fatigue-related accident to the extent to which you contributed to it. And the final area of legal research that we've seen change in the last couple of years is the principle of what constitutes the breach. So until recently, it was typically only in the event that there had been an accident that a company may be prosecuted, either both criminally or under civil or occupational health and safety law. But in Western Australia in 2011, we saw a landmark case in which the courts ruled that it's the creation of the risk which constitutes the crime for which you are prosecuted. In this particular case, it was a bakery that had violated the working time regulations for their delivery staff on a number of occasions. In this particular case, it was iconic because there had not actually been an accident. In this case, they determined that it was the violation of the driving time regulations that created the risk, and it was the creation of risk that created the breach, not the fact that there was or was not an accident. As was argued in the case, whether or not there was an accident is actually more to do with luck than it is to do with any systematic safety management process. And in this particular case, the company was then prosecuted for every breach of the driving time regulations rather than on the basis that an accident had happened. Now, if you take all of these cases over the last 20 odd years, there's a very important set of legal principles that emerge from this that will determine whether you as an organisation or whether you personally as a manager or an occupational health and safety professional are potentially liable in the event of a fatigue-related accident. The key principle that you need to understand is the notion of what's called reasonable foreseeability. Was it reasonably foreseeable that that individual would be fatigued as a consequence of the work practice or the system of work that you had in place at the organisation? And to the extent that you are actually responsible for the creation of that system of work, so shall you be responsible in terms of your personal or corporate liability for that. This process of reasonable foreseeability is an interesting one. We've been doing some work on this over the last couple of years. A PhD student of ours a couple of years ago went and worked in a mock jury environment to ask people in the community, at what point do you think it would be reasonably foreseeable that somebody had not had sufficient sleep in order to drive a truck or operate in a hospital safely? That research had some interesting outcomes to it, one of which was where we asked people to complete the following sentence. I don't think it would be safe to drive if I had had less than X hours sleep in the 24 hours prior to starting work. And what was very interesting about that research was that when we asked people that question, there were some people who said, you know, you probably shouldn't drive after 6 hours, and there were certainly some people who said, well, I've driven after no sleep. But the majority of people believed that once you had had less than 4 hours sleep, it would be reasonably foreseeable that you were at risk of a fatigue-related accident or injury in the case of operating a vehicle or working in the hospital. What's quite interesting, however, is when we asked that same people how many times they had actually done that themselves, everybody identified occasions on which they had actually driven while under their self-imposed limit on the amount of sleep that they thought to have. So that actually shows some of the cultural differences that still exist and some of the challenges around getting people to understand about fatigue. But that principle of reasonable foreseeability and what the courts and what expert opinion suggests are the case is what will ultimately determine whether you are prosecuted for a fatigue-related accident or injury. Unlike drugs and alcohol, where we have the general legal principle of what's called deemed impairment, we don't yet have an equivalent for deemed impaired for fatigue, which means, to put it in very simple terms, if you test positive for certain drugs or alcohol, once the alcohol is over 0.05 or the drugs are over the prescribed level of nanograms per milliliter or whatever it is for that particular drug, it doesn't matter whether you are impaired or not, you are deemed impaired. And on that basis, you will be liable for the consequences of that crime. This raises the second issue in what will happen in terms of fatigue in the next decade or so. As I said, as it currently stands, there is not a deemed impaired state for fatigue, but we've had conversations recently with a number of state governments who are starting to think around that level. There are some states in the US which are starting to look at the amount of sleep people have had in the 24 hours prior to operating the vehicle. And in that situation, they are suggesting that there may be some benefit in the community establishing a impairment level in the same ways that we have for other drugs and alcohol. It's probably hard to say where that line will be drawn at this stage, and I suspect the line will probably be conservative, at least initially. In the same way as we saw blood alcohol concentrations in Australia start at 0.1, go to 0.08, now to 0.05, and for example in Scandinavia down to 0.02, and in some occupations down to 0, I think we will see that same process where we might suggest that people typically must have a minimum of 1 or 2 hours, and then maybe over the next decade or in different cultures we may see that move up. The research on this is quite clear. Generally, once people's average sleep duration goes below 6 hours, and certainly by the time in the previous 24 it goes below 5, we can show measurable impairment and at a level that probably calls into question whether you can actually drive safely or not. Now, the general punter, when we talk to them in the mock jury trials, typically set the threshold at less than 4 hours. The researchers would probably draw the line at less than 5. Where the community will do that as a legal perspective, I suspect will probably sit somewhere around 2 or 3 hours to start with, but over time we may see it shift in exactly the same way as we've seen increasing sensitivity or lowering thresholds for drugs and alcohol over the previous 10 to 20 years.